Every asylum case has a story. A person fled. They are afraid to go back. They are sitting in a hearing room in London or San Francisco or Toronto, waiting to be believed. The expert witness report is how that story becomes evidence. It is 20 pages maximum. It must comply with the November 2024 practice direction. It must include a statement of truth that exposes the expert to perjury liability. It must be independent, bound by duty to the court, not the client. Today, we walk through every step of how we write one. From the moment the solicitor's letter arrives to the moment the report lands in the tribunal bundle. 8 stages. Each one we get right or wrong. Let's begin. You are watching the Human Rights Expert Witness channel. We are country expert witnesses based in London. We write expert reports for immigration tribunals in the United Kingdom, the United States, Canada, and the European Union. This video is part of our How We Work series. We show you our internal methodology, the same process we use on every case. If you are a solicitor, this video shows you what to expect when you instruct us. If you are an aspiring expert, this video shows you the standards. Every report begins the same way. A solicitor sends us a letter of instructions. That letter sets the entire scope of our work. If the letter is bad, the report will be bad. So we read it carefully before we agree to take the case. 8 things every letter must include. 1. The exact list of documents enclosed, with date and acronym for each. 2. Background of the case, immigration chronology, plus a summary of the disputed issues. 3. The specific questions the expert is asked to address. 4. The agreed fees, written down before work begins. 5. A reminder of the relevant practice direction. November 2024. 6. A statement that the expert must read the Somalia country guidance case from 2014, paragraphs 23 to 27, and the Pakistan Tribunal Authority from 2016. 7. A reminder to provide a statement of truth in the exact wording required by paragraph 9.4. 8. Confirmation. The letter will be submitted to the tribunal with the report as required by paragraph 9.3, subparagraph D. If the letter is missing any of these items, we write back to the solicitor before we start. We get it fixed. We do not waste hours writing a report on a flawed instruction. Vague instructions like assess the country situation. We push back. You need specific questions to address. Without them, the report has no anchor. Now we read the bundle. Every document, even the documents that contradict the case we are being asked to support. This is not optional. The Supreme Court of the United Kingdom said it clearly in Kennedy versus Cordia, 2014. An expert must be provided with and must consider all the relevant factual material in the case. Selective reading is not acceptable. The upper tribunal said the same thing in the Somalia country guidance case from 2014. The expert must consider all material facts, including those which might detract from the expert's own opinion. What we look for in the bundle. 1. The applicant's screening interview record. 2. The substantive asylum interview transcript. 3. The reasons for refusal letter from the Home Office. 4. Any witness statements from the applicant, family witnesses. 5. Country of origin information already used by the Home Office. Country policy and information notes. 6. Medical reports, if any. 7. Original documents from the country, summonses, court orders, news clippings. 8. Previous tribunal decisions, if this is a fresh claim or appeal. We highlight inconsistencies, not to expose the applicant, but to address them honestly in our analysis. Tribunals respect experts who acknowledge weaknesses in the account. Tribunals reject experts who ignore them. Country research is where most amateur reports fail. They cite Wikipedia, they cite a single newspaper article, they cite one non-governmental organization. We use a tiered hierarchy of sources. Top tier first, lower tier only when the higher tier is silent. Tier 1, authoritative international sources. United Nations treaty bodies, the Human Rights Committee, the Committee Against Torture, the Committee on the Elimination of Racial Discrimination, the Committee on the Elimination of Discrimination Against Women, the Committee on the Rights of the Child, United Nations High Commissioner for Refugees, eligibility guidelines for each country of origin, Office of the High Commissioner for Human Rights, country reports and High Commissioner statements, United Nations Special Rapporteurs, thematic reports and country visit reports, International Criminal Court, and other international criminal tribunals, judgments and findings. Tier 2, government sources. United Kingdom Home Office country policy, and information notes, but used critically. United States State Department country reports on human rights practices, European Union Agency for Asylum, country of origin information, Canadian Immigration and Refugee Board, national documentation packages, Tier 3, non-governmental and academic sources, Human Rights Watch, country chapters and investigations, Amnesty International, annual report and urgent actions, Freedom House, Freedom in the World Index, Reporters Without Borders, World Press, Freedom Index, academic publications, peer-reviewed journals, and university research centers, International Crisis Group, conflict analysis. One critical issue with country policy and information notes: they are published by the Home Office. The Home Office is the respondent in asylum appeals. The notes sometimes cherry-pick country information. The Albania note of 2022 was widely criticized for exactly this. We use the notes, but we cross-check against United Nations and non-governmental sources. On the 1st of November 2024, the first-tier tribunal of the Immigration and Asylum Chamber published a new practice direction. Paragraph 9 governs expert evidence. Every expert report must comply. Paragraph 9.1 says, expert reports should be as concise as possible and focused on the issues in dispute which are within the author's field of expertise. Paragraph 9.2 says, an expert report must not exceed 20 pages. Curriculum vitae, appendices, and references do not count against this limit, but they should still be concise. Paragraph 9.3 lists 12 specific requirements. Every expert report must contain them. First, the report is addressed to the tribunal, not to the lawyer who instructed you. Second, details of the expert's qualification. Third, details of any literature or material relied on. Fourth, attach the letter of instruction including the disputed issues. Fifth, a statement confirming what evidence was provided to the expert. Sixth, make clear which facts are within the expert's own knowledge. Seventh, identify who carried out any examination or procedure with their qualifications. Eighth, where there is a range of opinion, summarize it and give reasons for the expert's view. Ninth, contain a summary of conclusions. 10th, state any qualifications on the opinion. 11th, contain a statement that the expert understands and complies with the duty to the tribunal. 12th, contain the date of signing. Here is how we structure the 20 pages. Introduction and instructions. Who we are, who instructed us, what we are asked. Expert's qualifications, with curriculum vitae attached as appendix. Methodology, sources used, how we evaluated them. Country situation, current conditions relevant to the disputed issues. Analysis of the appellant's account. Plausibility, not credibility. Risk assessment, by refugee convention ground. Internal relocation assessment, if relevant. Sufficiency of state protection assessment, if relevant. Summary of conclusions, statement of truth, references and appendices. The upper tribunal confirmed in the Somalia tribunal decision from 2015 that non-compliance with the practice direction will affect the weight given to an expert report. Failure to comply diminishes the report's evidential value. This is where most expert reports fail. They cross a line they should not cross. Credibility, whether the decision-maker believes the applicant is the exclusive preserve of the Home Office caseworker or the immigration judge. We do not comment on credibility. Plausibility, whether the facts described by the applicant are consistent with what we know about the country, is what we are asked to assess. The Court of Appeal of England and Wales defined plausibility in a leading judgment from 2020. Quote, inherently surprising, or the kind of thing that you would not normally expect to happen. That is the expert's domain. The upper tribunal set out the 7 duties of an expert witness in the Somalia country guidance case from 2014, paragraphs 23 to 27. We follow them on every report. 1. Provide information and opinions independently, uninfluenced by litigation. 2. Be objective and unbiased. Provide independent assistance to the court. 3. Never assume the role of an advocate. 4. State the facts and assumptions on which the opinion is based. Do not omit material facts that detract. 5. Make clear when a question falls outside your expertise. 6. If the data is insufficient, state the opinion is provisional. 7. Communicate any change of view through legal representatives, even after the report is submitted. The language we use matters. We say, consistent with country information, plausible, given current conditions, documented by a specific source. My opinion is supported by the evidence. The language we avoid matters even more. We never say, I believe the appellant is telling the truth. The appellant is credible. The Home Office is wrong. The asylum claim should succeed. The appellant is genuine. Those are not our words to use. Every expert report ends with a statement of truth. This is the legal declaration that exposes the expert to perjury liability if they lie. It is not optional, it is mandatory under paragraph 9.4 of the practice direction. The exact wording we use is, quote, I confirm that I have made clear which facts and matters referred to in this report are within my own knowledge and which are not. Those that are within my own knowledge I confirm to be true. The opinions I have expressed represent my true and complete professional opinions on the matters to which they refer. Then we add a duty declaration. I understand that my duty is to provide the Immigration and Asylum Tribunal with an independent report containing factual information relevant to deciding an appeal, and that this is objective, unbiased opinion on matters within my expertise. I confirm that I have read the Somalia Country Guidance decision of the Upper Tribunal from 2014, paragraphs 23 to 27, and that I have complied and will continue to comply with the duties of an expert witness as set out therein. We sign with full name, date, and credentials. Printed clearly. We use a wet signature scan rather than a digital signature. Solicitors prefer this for tribunal bundles. We never predate the report. The date is the day we sign. Predated reports raise credibility concerns. Before we send the report to the instructing solicitor, we run through a quality checklist. Every report, every time. We learned each item on this list from cases where reports were rejected by tribunals. Page count under 20, verified. All 12 paragraph 9.3 requirements addressed, verified item by item. Statement of truth, correctly worded and signed, verified. Letter of instructions attached, verified. Curriculum vitae attached as appendix, verified. All sources cited with full references, verified. Inconsistencies in the bundle acknowledged and addressed, verified. Language scanned for advocacy phrasing, verified. Date matches signing date, verified. Spelling, grammar, names of appellant and places, proofread. After we send a draft, the solicitor often comes back with comments. We welcome legitimate feedback, clarification questions, requests to address an additional disputed issue, corrections of factual errors about the case file. What we do not accept, pressure to change our conclusions, requests to remove material that weakens the case, suggestions to soften language that the solicitor finds unhelpful. Our duty is to the tribunal, not the client. If a solicitor pushes back inappropriately, we politely refuse. In the reference Civil Procedure Rules, Part 35, Rule 3, our duty overrides any obligation to the instructing party. Once the report is delivered, it joins the appeal bundle. In most cases, the report stands on its own. The tribunal reads it, weighs it, and issues a decision. In some cases, usually the more complex ones, the expert is called to give oral evidence. This is what to expect. You confirm your identity, qualifications, and adopt the report as your evidence. Counsel for the appellant asks you to clarify or expand certain points. This is called examination in chief. The Home Office. Presenting officer cross-examines you, often challenging your sources or methodology. The tribunal judge may ask their own questions. Counsel for the appellant may re-examine. You answer based on what is in your report. You do not introduce new evidence orally. We prepare by rereading our own report the night before. The cross-examination will focus on the weakest links, usually source quality, qualification challenges, or alleged advocacy. We are ready to defend each section. If asked about something we do not know, we say so. Quote, I cannot speak to that. It is outside the scope of my expertise. That answer protects credibility. Speculation destroys it. The Immigration Appeal Tribunal warned in a Somalia decision from 2004, the expert's qualification must be demonstrated, not merely asserted. If your curriculum vitae does not show specific expertise on the disputed issue, the tribunal may reject your evidence on the spot. 8 stages. From the solicitor's letter to the tribunal hearing. Every step matters. Every step has its own rule, its own pitfall, its own best practice. This is how we write in expert witness report at the Human Rights Channel. It is not the only way, but it is the way that complies with civil procedure rules. Part 35, with the November 2024 practice direction, with the Somalia country guidance case from 2014, and with every other authority the Tribunal will check against. Next in this series, how we verify documents from over 50 countries. When a solicitor sends us a summons, a court order, or a police report from an asylum seeker's country of origin, how do we check it is genuine? That is the next video. Subscribe to the channel. If you are a solicitor, save this to share with new instructing officers. If you are an aspiring expert, watch every video in this series. I'll see you in the next one.